immediately following land use, and we took a break, so I'd like to call to order the Rules Committee. First order of business is the last time this committee met is the approval of the November 27th, 2018 minutes. But I guess I'll start by thanking the group to meet. We typically don't have to meet very often, but the Rules Committee has to meet prior to a new board being set so that we can set the rules that this board lives by and follows as our rules for the board. So today, I'm not looking for a whole lot other than that we needed to have a discussion, open these up, and then we'll need to approve them before a new board gets set. So I've asked Scott to include this in Friday's minutes for all board members, a copy of the rules if they didn't have one. And then what we'll ask is for board members to send suggestions back to Scott if they have any. And then in our next meeting, we'll move forward with that and we'll decide this. This committee is set up of myself, Member Salzer, Member Fennell, and Member Williams, also with the consent of Chairman Rand. So that's this committee. We'll go through it, but first order of business, since we haven't met in 2 years, is the approval of November 27th, 2018 minutes. Mr. Fennell, Mr. Salzer, any questions or comments? Seeing none, we're going to move to all those in favor. Aye. All those opposed? The ayes have it. Next is a discussion of the 2021-22 Peoria County Board Rules of Order. Again, I believe these can be changed at any time through this committee, but we do need to set new rules. This is typically when we review them to set there. You want to go over anything? Or should...
All good, Mr. Chairman.
So everybody should have received a copy prior. I know I've read them. I've got some changes that I'd like to discuss. Simple changes. So I'll go through some of the things that I highlighted that I saw maybe that we need corrected. Open to any suggestions. Is the state's attorney on the line?
Yep, I'm here.
Do we need to make approval for her?
No.
Okay. Okay.
Nope.
Jenny, I know that Scott's talked to you some of them, but one of the questions I had is, do we need to enter in a COVID type language into these rules to make it easier? Many times we have the chair that has to make multiple suspension of the rules. I know, as Chairman Rand stated, that's because of executive orders that have been issued by the state for suspension. But just give it some thought if there's anything that we need to add into it per COVID. Is that a hand raising, Chairman Rand? Go for it.
Mr. Chairman, thank you. And Jeannie, who is anybody else on the line except council?
That's it.
Thank you. Welcome to our meeting, Ms. Cordis Boswell. I'd like to point out that we have been really stern, and I think that's the word, in the 11 or 12 years I've been privileged to serve, to not make it easy to meet telephonically or by now every version of a Zoom, a Teams, a WebEx, a Cyberforce, a G.I. Joe, for a reason. And that has been because this is the people's chamber, and they should have an address and a place that they know that they can go and they can access without having to know what a laptop is from a lap belt. I could work on my similes later. So I dare say that we make it easier to permit meetings to be held electronically, whether by, computer or telephone. Now, we have permitted participation in meetings of committees of this body by telephone because, fill in the blank. It has, to me, largely accommodated the needs of agricultural district members. Occasionally, it accommodates the needs of traveling members on business. And I don't recall whether rules permit a non-business reason to be the reason you dial in. I know it is that way at the city. You really must declare and so state that you're on business. I don't know if you have to raise your hand, and they only let like one of them at a time do it that way. And then they're eligible to vote. In committees, we're eligible to vote, and we have to use the governor's, waiver of our, all the OMA stuff to permit us to vote electronically as when we meet as a board. Now, before I confuse the heck out of everybody, there's been a reason we've wanted to cause people to meet in person, and I wouldn't want to relax that. The condition I think Mr. Dillon is speaking about is, since COVID's probably not going away by March, or the inferences of COVID, do we need to have an opportunity whereby, say, supermajority, we could amend our own rules in the middle of a year without amending the rules to permit some additional flexibility in how we assemble because of pandemics, or before that it was weapons of mass destruction, sort of junking up the environment. So I think that's really the question, Jimmy, you're saying is, do we need another mechanism to open the whole thing up without getting a governor's order? Now, frankly, I'm not sure that we can amend anything that the governor has given us a special dispensation on, because this may be a requirement of state statute that we're meeting in public. So there may be zero flexibility in here anyway, and I think that's what we wanted Ms. Boswell to research, right?
Yeah, because I think it's important. Oops, sorry. Go for it, Jenny.
I was going to say, I can speak to that a little. So the Open Meetings Act obviously requires people to be physically present. It does have the language in there about if you are gone for employment reasons, it's employment purposes, personal illness or disability, or a family or other emergency. It allows you to attend by video or audio conference. We, in your local rules, the reason that we always have to suspend the local rules is because at county board meetings, your local rules does not allow for people to be absent, even though the Open Meetings Act does allow people to participate remotely. But you allow it for committee meetings. You allow those OMA exceptions. And so we suspend the local rules in order for members to participate remotely in county board meetings. And that's only because of the governor's executive order is allowing us to have those relaxed OMA provisions. We can adopt those. We don't adopt them. They're just in place through the executive order. So as for your local rules, you really can't adopt something that's going to allow for virtual or remote meetings any more than you have now, because we still have to operate under OMA, which only allows people to participate remotely in those three narrow exceptions. You could amend your local rules to say that those three exceptions also will now apply to board meetings and not just committee meetings.
And Chairman Jenny, I know this is prior to you when you started, is that when we started the phone, everybody in here might be around long enough to remember this. When we started the phone, we included the option, if one member chooses to deny it, then they cannot participate. And that was because we had some members, there was a discussion among the board of, if you become elected, you should attend meetings. And we felt some board members were coming up with unlegitimate excuses of just not driving into a county board meeting. I know Mr. Fennell has a 20, 25-minute drive Um, it's not an easy drive. We all have different drives to get here. So that was in the place. And I'm not looking to change the rules. I just know if we needed to talk about it as technology changes, we've always had the call in there. Do these TVs have the capability where you could put a couple county board members on it where it's via Zoom? Or do we allow, I know we've dropped the rules for, we had some members that were, for health reasons, not wanting to come in to a full county board where we've let them vote. Does the new full county board allow participation like the committees do? Those were the questions that I think that we need to probably clear up, exactly what you've talked about. I don't want to change anything too drastic, but we probably just need to have some clarification, if that makes sense. Are we on the same page, Chairman?
Yeah, I think so. And the three specific reasons that the council cited for participating by alternate means for our full board meetings, I'm not sure I want to put them in. I think she's saying that you can use that exemption, but then somebody has to police that. And as you know, we can't police one of our own members now. So who simply doesn't want to come because he doesn't want to wear a mask. So I don't want to get into policing it because we can't.
No, agreed. And I think that's why you've always had the one member can choose to pull it out if they choose. Mr. Fennell?
One suggestion might be to limit the number that any one board member could do in a year's time. Maybe three committees that you could do it. I don't know. I'm just throwing out stuff. But obviously, we're all on more than one committee. So it might be, and I don't want to get into something that's a lot of mathematics to check out, but it might be that 3 wouldn't be enough because of the multiple, but 3 for one committee, one particular one. I don't know.
My main thought is the pandemic isn't going to end anytime soon, per
No,
se.
it's not.
And that I know we have some members that are, rightfully so, we all are concerned about health and would prefer an option of being able to call in going forward still. So I just want to make sure that we have some very smart and talented members that contribute to this county, and I don't want to see them have to step aside because of something like this. And one of the reasons I know for me, it was always, I never did call in often, but as it was also designed for people still working too, that if you were on the road or if you were traveling, or there was times when I was running back from work, I could call in on my way down here just to make time. So I was trying to alleviate and make it easier for some board members, the time commitment. So that was one of the time frames. One of the things I thought of was a question of special meetings, which would have been page 3, section 4, part A. It says special meetings of the county board shall only be held when requested in writing and signed by at least 1/3 of the membership. So that's 6 members, basically, and then you turn that into the county board. I was wondering, one of the suggestions would be potentially, should we add with the approval of the vice chair or chair? So that would make a 7 signature, or as long as one of them counts, or have 10 members, which would be the majority of the board, sign without approval of the vice chair or the chair. And the only reason I say that is not that anybody has, I've never seen it, but let's just say 6 members of this board wanted to start gumming everything up because they're in mass disagreement. You could start having somebody sign a form, turn it in every day, and not even show up. So that way, at least the chair, the vice chair, would have to sign it, or if a majority of the boards, even if the chair or vice chair refused to sign it, a majority of the board could still force the meeting. I just didn't know if that's something we should look at from a rules perspective. 6 has always worked, and I know sometimes for Jan it's probably hard to get 6 signatures, but it was just a thought that I had of, not that this county board has ever been in that, but you look at DC politics where you could see where you could just have meetings for the sake of meetings and not show up. I would hate to see something like that from county staff time come without a serious county board effort. Another item I had was citizens' remarks, which is page 6.
Mr. Dillon, before you move on, I just want to ask Ms. Cordis Boswell the question: if 6 people cause a special meeting to occur, and only those 6 people show up, how do they conduct the business?
Lack of a quorum, they can't. I'll let her answer.
What was the end of the question? If they're the only 6 people that show up, what?
By rule, how do they conduct business? If there's no chairman, how do they conduct business? If there's no vice chairman appointed to substitute?
Well, they wouldn't have quorum to do anything. Wait, you said under this one it would be 6 member. Yeah, so you wouldn't have the quorum. And yeah, I think you got your local rules. You have the chairman, and then vice chairman steps in if the chairman isn't present. But I don't think you go beyond vice chairman. And I'd have to look at that to be certain.
Ms. Boswell, there's a portion in the rules where the chairman can appoint if the chairman and the vice chairman are to be absent, the chairman has the authority to appoint a pro temp.
Okay, perfect. So yeah, they wouldn't really be able to have their meeting anyway, or they couldn't. I guess they could meet just like anyone could, but they couldn't take any votes, and they really wouldn't be able to conduct any formal business that way.
So change it and say, suppose there are 10 members present, which would constitute a quorum, but there was no chairperson or vice chairperson or appointed pro tem. How could business be conducted?
Could you repeat that, Jimmy?
So if 10 people show, the chair and the vice chair do not show, and the chair has not appointed anybody to be chair, how could business be conducted?
It's a good law school exam question. I'm sure that there's, I'm not sure you have to have a chair in order, well, if there's an agenda, if there's a posted agenda and you had a quorum, you know, they might just be able to vote to appoint their own chair, or just a vote to suspend the local rules that would allow them to proceed without a chair, or to appoint their own chair. But I'm not, yeah, that would be something we'd have to dig into to see if that's ever arisen. How do you conduct a meeting without a chairperson or a pro tem chairperson in place?
Well, and part of the reason I brought this up is because if you look at committees, the chair sets the agenda. The chair dictates when meetings are called. The only way you can overrule it is if a group of the committee, a group of the board would petition not to. So the idea was to allow the chair and the vice chair to at least control part of the meeting, so that you don't just create meetings to have meetings. Not that we've ever had it, but it's allowable under the rules. Chair or
we did earlier this year have a situation where the chair and the vice chair were unable to attend, and if you remember, Mr. Dillon, you were appointed because you were the senior member of the committee present. And we had you chair our infrastructure committee. Going back to what Mr. Rand asked and our legal counsel, that's what I was thinking, same way as she was in regard to 10 members. They suspend the rules and make their own rule in regards to appointing their own chairman. Then I would think that would be legal for them to proceed with whatever action. Now, getting back to what we started on, 6 members. 6 members sometimes was made to protect the minority. In other words, this is more minority rights, only having to have 6 people to call that meeting and so forth. But those people who are in disagreement with them, they just don't attend, so they don't have a quorum where they can compete and so forth.
Yeah, it's never been a problem. I just thought as I was rereading it, I just thought I'd bring up comments, see what other people thought about it.
I was just trying to think of a topic that wouldn't be defined by one of the committee chairmen, that it should go under that committee, you know. If you had that, an issue you wanted to discuss, it should go to one of those committees, put it on that agenda to be discussed. That seems the more appropriate way to do it.
And if you recall, I mean, I know Chairman Rand refreshed my memory earlier. There was, before we had talked about Headington Oaks and we were trying to work things, there was a demand by a few board members to hold public meetings, and board members decided that we were still working through things and we weren't ready to have those public meetings yet. And I know the chair exercised his rights and said we're not ready there yet. So I was just thinking of similar circumstances like that, where we're working through things and through committees and through things where you could have 6 members try to force an issue and have a committee of the whole when it's not ready for the committee of the whole. I was just thinking through it. It's never happened in my lifetime of being down here, but if we're going to look at the rules, I was just thinking of the rules. Do you put in some calculators of that, you know, the chair, the vice chair? Historically, in my whole time we've ever been there, we've been bipartisan in the chair, in the vice chair, and the chair. So that would not be a partisanship issue. And then if you could get to 10, that would say that the majority is interested in having that meeting. And I use that example of, say something happened to the chair or the vice chair and the majority of the board wanted to rebuke them, not that we have much clout in that to do that they couldn't stop you if the majority of the board wanted to go forward. But it also doesn't allow 6 people to dictate to 18 people when you're going to have a meeting, unless you have approval of the chair or the vice chair. And I know it's difficult for Jan sometimes to get signatures alone, but it was just a thought, a process. I think maybe give it some thought. If everybody says, no, it is good the way it is, it's good the way it is, but it's something that always can be revisited. That was just one that stood out to me. Is there any further discussion on that one, or I'll move to some other thoughts?
I just want to ask a question. Maybe I missed it in there somewhere. Can't the chairman call a public meeting? He doesn't have to have the approval of our membership.
According to you have the scheduled ones that are on the calendar, but according to our rules, you have to have the 6 county board members call the meeting. That's why when Mr. Chairman Rand and Vice Chairman Fennell have called meetings in the past, you have to have the 6 signature sheet that's signed. Or else if he could just call it, he would not need those signatures.
Okay. All right.
Am I right on that assessment of the rules?
Correct.
The next, under citizens' remarks, and Jenny, this is a question towards you too, is that, and I don't know if it's happened since you've took over, but citizens' remarks, page 6, the first one, it says, members of the public who wish to address the board must provide the chairperson with a written notice of their intent to speak prior to the meeting being called to order. So basically it says the pre-printed written notice shall request a name. So it says you basically have to submit in writing before a meeting if you're going to speak. On very few occasions, most times we've held tight to that rule, but on very few occasions there's been times where somebody did come late, there had been not many people prior to speak, and it said the chair has recognized to the board would there be any objections to speak. Technically, by our rules, that's not allowable. If a board member would call that out, you should have to suspend the rules to allow somebody to speak. So I was thinking, do you need to put in somewhere in there, unless the board or the chair grants ability afterwards, just to clean up the language of saying, because right now I think it's happened maybe once. Does it even happen once a year, Chairman? Maybe once a year where he grants somebody that came in 2 minutes late and if they've took the time to come down here, we've allowed them to speak. So I thought maybe if you put in there at the will of the board or chairman or chairperson, sorry, that would allow, that way it would be within our rules.
Yeah, I think you could provide a sentence in there that upon, a board vote, someone could be allowed to speak even if they hadn't pre-registered. And I assume that written notice that has to happen prior to a meeting is just something as simple as filling out a form at the door when they show up.
Correct. They have to provide their name. I don't think they legally have to provide their address according to the rules.
Correct. Yep, that's right. Yeah, you can't force them to do that. The other provision in this section, number 3, I'm not sure that would hold up. They certainly can't debate members of the board or ask questions. They can just speak and give their comment. We definitely don't have to answer their questions or debate them. But the part about speakers refraining from identifying people by name or disparaging or condemning people, that is probably protected speech. The government probably cannot stop people from coming and criticizing, condemning, disparaging. Now we could do something like you can't use profanity or they couldn't get up and name off Chairman Rand's address and tell somebody where he lives and how to find him to harass him. They couldn't do something like that, but I think they can stand up and condemn and criticize individuals.
Personally, I would like you to look into that one further because we've used that one quite a bit where people have came in and tried to harass. It's not much as disparaging as much as it is harassment of staff and false statements. And Chairman Rand has done a very good job of, you can speak to what the matter is, but you are not, and you can name an employee, but you are not allowed to. Some of them have gotten ugly on comments made towards people that I wouldn't even say to be true facts. Chairman?
Yeah, I'm following what counsel is saying. I would prefer to let the Illinois Supreme Court to decide whether we could throw the flag and interrupt somebody, because I really do think, Jenny, it's important that decorum be maintained. If civility is expected of the members, there's no reason the public is disqualified from that. So, and then I would just also say to you that I forget which former state's attorney has said this, but one of them has. This is a public meeting, not a meeting of the public. So to the extent that we have rules about how we are meeting, should also govern any comments made to that meeting. Now, if it's going to a meeting all about public input, and much like a committee of the whole really is sometimes, I see a distinction there, but we're here to conduct our business, and it's certainly a right of every person, I didn't even say citizen, to have access to this body, but it's a meeting of the body, not the public.
I would agree with that. I think decorum.
Thank you.
Yeah,
Thank you.
It's your meeting and it's
Thank
open
you.
to the public.
There's a
but
judge up on the third floor of
think-
another wing you might talk to. That's the first time I heard it said. It's a public meeting, not a meeting of the public.
Thank you, Chairman. Any other questions about that? Next, would be page 10, section 28, and Kathy's here to speak on that. But there is section 28 basically lays out that any zoning matter presented to the board pursuant to zoning ordinance of Peoria County, Illinois, or compiled statutes of the state requires a 3/4 vote of all members of this board. For the approval thereof shall be submitted to the vote of this board only if 16 members of this board are in attendance at the time of the vote for the matter. But then if you go at the end, the last sentence says, upon a written request of the petitioner or an oral request at the meeting of the board by petitioner, the matter shall be submitted to the vote of this board when less than 16 are present. So Kathy has the rules and state statute, but there needs to be a little cleaning up of the language in here, and I'll let Kathy speak to that.
Per statute and also per our ordinance, the only time a supermajority or a three-quarter vote is required is on a rezoning case. In instances where there are objections by 20% of adjacent property owners of the property to be rezoned, or 20% of the property owners of the property to be rezoned, or by a municipality within a mile and a half of the property. If they file those objections with the county clerk's office, then that three-quarter majority vote is required to pass. There is in the statute nor in our ordinance, there is not a waiver per se that the petitioner can request that the board vote with less than that three-quarter. I suppose they could vote, but there's no way they could pass it without the three-quarters, so it wouldn't make sense.
So that last part would probably need to be stricken, and I would just ask for Kathy, maybe with Jenny, to write some new language for this to be a little clearer, and definitely eliminate that last statement. I would be okay even with putting the rezoning purposes in there, so that for board, it just seems it's awful vague on what it's trying to define there. Next is the standing committees. So if you would go to page 12, line G, staff assistants. I was always under the understanding, but according to this, it does not, where it says the respective standing committee shall approve county board members' requests for staff assistance that requires more than 2 hours to complete. So there has always been the 2-hour rule that if you generate more than 2 hours worth of work for a staff person, that it has to have approval. That I was always under the understanding that was the privilege of the chair to grant. So the chairman of the committee could stop or start that instead of having a vote of the committee. I know it's happened in land use or something where even I've talked to, say Mr. Fennell came and asked about something. I talked to Scott, Kathy. It's always been proper protocol to go through the committee that the structure goes through. So I would ask that language be chairperson instead of committee. And that was always been basically, hasn't that always been somewhat the unwritten rule of?
Correct, Mr. Dillon.
So that would be in there. The executive committee, if you go to page 13, I think you leave. I think you need to pull some of my thoughts on this, but I'm just throwing them out there for suggestions, and that would be, I think you possibly pull Headington Oaks away from health with wayward direction and the referendum, and put that under the purview of executive decision or executive committee. I also think that you pull legislative affairs from Ways and Means and put it back into the purview of the executive committee. If you remember in the past, when I first started, that was always part of the finance committee. It was always called finance and legislative affairs. Then it left when we looked at the finance even tighter. It left finance and went to budget. And then when Mr. Mayor was in charge, he loved legislative affairs, so that's why it went back there. But I think legislative affairs is an important enough issue that it goes back to executive, and a broader portion of the board has input. I know all the that way the committee chairs also have input on that, because there's been times where things from land use or infrastructure, I know Scott asked all department heads, but it would be wise to have the committee of all department chairs and vice chairs go over that. I think you keep Metro Peoria committee. I know it's been dormant for a while, but just leave it as a dormant. And I know I'll leave this up to the Chairman Rand's thought and preview. As I think this is where the Social Justice and Equity Committee, we would need to create a line item for that new committee to be put in here also. So that's executive. I think under Ways and Means, which actually under Budget Committee is a preview of that. I know Chairman has some thoughts about finance and budget, but I would think, and Mr. Fennell, you're the Chairman of Budget, but I would think that under Ways and Means, the Finance Department reports to that, but I would think the Finance Department should report to Budget Committee, being that that's the main reporting that's given there. So that was a thought. Another thought was under the county health committee, since you're taking out Headington Oaks, I think that you add the ROE because education is a priority in this community for the mental and physical health going forward. The corner, the EMA, because the EMA is part of the public health department, and you add recycling. So I think those take the place of some of the stuff, especially I believe county health is an important committee, especially considering with light of everything that's been going on here recently. And lastly, E, just draw attention to it that we have it in there. The Minority Business Ad Hoc Committee, that would be a question, but I don't think it's doing any harm by sitting in there as part of the rules at this point. Those are the things I'd like to draw attention to that I've, through me reading them. If you have any questions, comments, those are some of the suggestions. Maybe if we could, if I don't hear anything, we could get some red lines for the next meeting going forward, and then move forward with, I would ask if anybody else after this meeting and after the whole board gets it, send suggestions to staff for Scott to put together, and then we'll get them to this committee to review, because we will have to have another meeting prior to that. So we'll have to see how that works, whether we have another committee meeting before the county board or have to have a special meeting to move this forward beforehand, but we'll have to set the rules. So Sharon, did you have your hand up?
I just, on the Minority Business Ad Hoc Committee, are they meeting at all?
No, currently that is a dormant advisory committee.
So my thought on that was, why can't we make that part of the Racial Justice and Equity Committee?
I probably have a grander concept to use Dr. Blair as a committee lead for all of our economic development incentives, which I think is a separate conversation. Even Dr. Blair and I have talked about that before. I think she's got some real skills we're not tapping. I think I've talked to you about this too now I think about it, that we're not tapping into. So that subject per se has been dormant since, well, even before Rachel was appointed to the auditor clerk's office. Jimmy, I have several comments that I don't need to make today about some of your suggestions. I think you're just trying to loosen the tires up on this thing a little bit. The structure of these committees traditionally has been used to make committee chairs and appointments. I have done my best to avoid that by being more inclusive, although my friend and colleague, Mr. Fennell, would say it hadn't always worked out for you that way, but I've still been inclusive. The agenda for the board going forward prior to the election, right? Yes, the chairperson has a lot to do with this conversation. It usually comes after the general election, so we know how many votes we all got in this room. I applaud you for starting this conversation before that. Although I'm not on the ballot, neither is Jim. It's important that we start this conversation at least once a year. And that's the first note I made when you started talking was, we shouldn't be looking at some minutes of the last meeting to approve from 2 years ago. Did you say 2018?
Yes.
Yeah,
November
so
2018.
one of the rules we ought to have is this committee's got to meet at least once a year. Secondly, several of the things that you talked about with respect to committees, I hear from members all the time that want to do this or want to do that or have some personal passion for certain things such as ecology of the environment or energy. That would clearly be our cohort, Kate. we asked Sharon specifically to take on a project that included a full examination of the operations at Headington Oaks. She concluded that examination before it was time to reappoint the committee. So I mean, some of these things have really been with purpose, and some have been meant to be apolitical, and some of them have been meant because they match the times. So the subject of social social justice and racial equity, I got to keep my words straight, it clearly is a topic that members have talked to me about, and it's something I think we should support. As it fits into the old minority development thing, I don't see it fitting there. I do see Dr. Blair's skill set really being able to work on that better than we ever have. And of course, Jim and I just trade each other's pitches for, you know, whatever the subject of the day happens to be. But, you know, some people can make these committees work really well, and some can't. We've had large projects in the past before where we constructed Headington, we constructed a museum. I mean, so a lot of the work product in front of us, not behind us, was how these committees got built. In years past, they were really built to get a chairman enough votes to be elected chairman. And I'm really glad we're talking without that context in front. So I applaud you for getting it done now. And Jim, as vice chair, has been a super capable committee chair as well for budget. But that's the way we designed the executive committee, was to get every assistant and chair in a room, plus the chair and the vice chair, as an inclusiveness role. I think it's benefited us to get that kind of consensus, even in difficult issues, worked out before we had to come into this room and make some decisions. So there's a lot of reasons the structure exists as it does today. Some of them stink, perhaps, if you're a certain member or two. But I do think we ought to reassess it and ask the county staff how it impacts them too, because they have to staff all this work. There's a lot of questions that get asked, a lot of data requests get made of them. So I think we want to be mindful of that conversation too. And finally, you know, we have interfaced differently with the electeds in years past. We might try a different way to interface with them now, but there is certainly an opportunity for an efficiency group between the state's attorney, the sheriff's department, and the chief judge and court administrator to figure out how many heads and beds we have that are costing us in this budget a $1.1 million general fund transfer that's anticipated out to the JDC. And, you know, I think there's some real upside in how that works together. But if we make it a committee of the board, it's subject to the Open Meetings Act. A lot of public officials don't like to work in the same OMA world that we do because they don't have to. So there could be some ad hoc committee appointments that don't require OMA, and I'd like to know from the county attorney how to do that. May not need to be in the rules at all.
Right. Well, I'll work with the State Attorney's Office, Mr. Chairman, to figure out what that solution might look like.
And the chief judge is kind of up with it, right?
Yep, correct.
Thank you. Thanks, Jimmy.
So the sake of time frame, too, if this board is agreeable, this committee, if we send it out on Friday, that would give time for board members to review, send back comments. For the sake of everybody's time, I know it's important, but I know it might affect you, Chairman, but if we could meet again before the next county board meeting, so we don't have to create a whole nother day of everybody coming down here, since we would all be down here anyway. So maybe have a 5 o'clock meeting to discuss any red lines, any comments that we receive from the board. That way we can keep with the schedule of possibly still being able to approve. I'll let Scott give the time frame of when. So obviously next Tuesday is the general election when you'd be voted on, but the seating of the new board is.
Yeah, sure. Happy to, Mr. Dillon. So your regular business meeting in November is Thursday the 12th. So if you wanted to have a committee meeting on the afternoon of Thursday, the 12th, we're happy to schedule that for you. Right now, November committee meetings are tentatively scheduled for the week of Thanksgiving, but we'll be talking to all the committee chairs and looking to probably move those to the week after Thanksgiving, which is the week of November 30th. The new county board is seated on Monday, December 7th. Your posted regular business meeting for the month of December is Thursday, December 10th. That's also slated to be your budget meeting as well. And barring the need for a special county board meeting, the December 10th meeting would be the last time the full board meets in calendar year 2020.
So basically, those are our timeframes of around 12/7. 12/10 is by the time we need to have the rules done.
Correct. In the added component that the chairman of the elected county board chairman will have between the 7th and the 10th is most likely looking at committee assignments and trying to make those appointments on the agenda for the 10th so that we can conduct committee business for the January county board meeting.
Really, I should have started this process about a month ago.
You
So-
did. You called me about it.
So, Coach?
Mr. Chairman, can we talk about some other areas?
Yeah, anything that,
Now my paper is not correct. I must have gotten this, sent to me, and then there must have been a revision or something after that. But mine is on page 5, and it's number 8 under the membership. So yours might be about 4 or so. But if you look under membership, Article 2, and go to number 8 on B where it says duties. So officers of the board and their duties, chairman, chairperson, and so forth. And then you get down there, and it's number 18. It says vacancy in the chairmanship. In case of resignation, death, or other creation of a vacancy in a chairpersonship, there shall be a new election for the chairperson. And I understand what is protecting there. But it doesn't say how quickly this has to be done. Should it be done at the next regular meeting, or should we call a special board meeting?
Phil, I think the statute requires us to appoint the replacement member in 60 days already.
That could be a couple meetings.
Well, it could be, and in which case you have a vice chair to conduct business. The vice chair is not permanently appointed. It's not a secession thing where you become the president of the United States.
I know.
So the rule currently, the statute is 60 days. Just giving you that info.
what are you asking, Coach? That
Well,
it should
well,
be at the
I just think
next
that-
full
He's trying
board
to make
meeting?
it quicker.
I just think,
At the next full meeting of the board? there
that,
should be an
yeah, it should
election?
say when this election should be held. I know you're using the state law of 60 days, but
Well, it impacts whether another member is in the room to vote on a chairperson election. So the vacancy, you have up to 60 days to do it. If you wanted to elect the chairperson with that member to be decided later, you still could do that.
now I'm just looking here, Mr. Fennell, who happens to be of a different party, and he's been
He's
very
from the American Party, just like us.
He's been very reasonable, and I look at this and I
He's
know how
been beyond reasonable. He's
I
been
understand.
awesome.
I understand. But what if it was not Mr. Fennell and another member of the board, where possibly they're not reasonable, and they have a bunch of appointments to make.
Chairman, I think the question is that technically the chair gets the appointment, so there wouldn't be an appointment per se of the new person prior. Because you technically have the duties, you assign them to the vice chair. The vice chair serves in that role as needed. I think there's a question in here if something would happen to you about, and the vice chair, about who could sign legal documents on behalf of the county. Because I don't think as many people realize how many documents you sign a month for stuff. So I think the only thing would be in there is that maybe the board, at the next full board meeting, that is that your concern, that it could go months without?
It could. And I don't want to.
Technically, if something happened to you, Chairman Fennel at the next meeting would assume this role, and thus Chairman Fennel is looking to run for chairperson. You cannot sit in this seat if you're going to be nominated for chairperson. So if Chairman Fennel then at the next meeting ran this meeting, he would, and then
You have to appoint a temporary chair like you do at the reorg.
you have to appoint a temporary, yeah. So that would be the question is, and I guess that would be a legal I know the 60 days because that was the first thought of mine, but it's 60 days for the appointment of your seat. It's not 60 days for the appointment of the new chair.
Thank you.
The other question could be, you say at the next board meeting, a person could die a week before, and then all of a sudden, to react that quickly is pretty quick. So I think just saying the next board meeting,
Or you can say a special board meeting called by the,
yeah. But it's just
Yeah.
something to think about when you're talking about the time frame of the next board meeting.
Unless you say something that a board meeting shall be held within 30 days, and, define what that time frame is.
If you guys will spend a little time with page 5 and your, actually 4 and 5, the duties of the chair and vice chair are pretty specific. Paragraph 8 regarding duties of the chair, vacancy in the chairmanship in case of resignation, death, or other purpose for the vacancy. There shall be a new election for chairperson.
Mm-hmm.
So if you read then what the vice chairperson's duties are, is he or she is to act as the presiding officer in the absence or temporary inability of the chair to conduct a meeting. This does not appear to me to give the vice chairperson the power to make the replacement appointment of the vacant seat. It does, however, give him the capacity to preside at the meetings. So the rules require you to have an election for the chairperson, but to Phil's point, it does not say when. And so it's a little bit interesting.
And I guess that's the consideration, Phil, of why we've trusted Chairman Rand and we've trusted Mr. Fennel. That Mr. Fennel, it would be in his decision, as if something happened to Mr. Rand per se as the chair, that he would set the guidelines and bring the board together, just as Chairman Rand had done during other prior passings of the board. So I guess that stresses the importance of who we elect as vice chair and chair too.
and that's somewhat why I'm,
Think of a
Why I'm
9-9 board, okay?
Oh, yeah.
And suddenly one of those is missing, on a 9-9 board, or even, quite frankly, a 10-8 board, and one of the 10 hates the chairman.
Yeah.
So, it is what it is. It's life. I don't think the rules are meant for us to sort of control outcomes. I think the rules are meant for us
Can't
to
reach
guide
after the grave either.
guide process. Yes, correct. I've seen a testament, last will and testament do that.
Yeah.
Hand from the grave.
Yeah.
Coach, did you have a comment?
well, you guys can do,
Phil, you've been looking at these rules for 25 years, and you're just bringing this up now?
well, I've not been on this committee for 25 years.
Ouch. Okay.
The other one that I was questioning, and I talked about it earlier under the special meetings, and every organization that I've ever belonged to, that president of that organization, and that's what Mr. Rand really is. He's the president, just by a different name. We call him the chairman, and some county boards do call their chairman the president, but that president or that chairman in all the organizations I've ever belonged to had the power to call a special meeting anytime. Now, under the circumstances that we have 6 members, he's a poor chairman if he can't get 6 people to call a meeting, as we have it there. But I still think that the chairman has the right to call it board meeting, a special meeting anytime. I think that's one of that particular individual's powers.
Does that also count towards the press conferences? Do they still have to get the 6 signatures for that too?
For a press conference? Not unless,
I'm just
no, because we've had dinners and stuff that are posted that you have to post it more than a quorum of a board is going to be present, but unless official business is taking place. But if I know there's been press conferences.
I just didn't know what practice was. What's past practice? Do you have to have 6 signatures for? No, good. Okay, that's all I
No.
want to know. That's
Any other questions, Coach? You have more?
I guess not.
No, I can see you got a question on your face. What is it?
That's all right.
Sharon?
Well, one of the things I was thinking of, and I've mentioned this to Scott in the past, is that once COVID is over and we're back to normal, I'd like to see that our meetings continue to be streamed live, our committee meetings streamed live. I don't know if we need to mention that in there, but, I just think for transparency purposes, I would like to make sure that we keep the public aware of
That's
what
part
we're
of
doing.
PR and marketing. I don't think we need it to have it in our rules to continue that practice. Coach? Got a hot date?
Certainly.
Mr. Fennell, any other thoughts, comments?
No, I think you've opened the door on a lot of conversations here, and hopefully we get a lot of good report back from other board members of things to.
And then I believe an hour should be plenty good enough for prior to the meeting, I would believe. Or do you need? Yeah, would you put a final date on that so we have it before
The committee, if we put them in this week's administrator update packet, have feedback back to me by next Friday? Is that
Honestly,
acceptable?
Jan, could we just probably do just a separate email to all board members tomorrow?
Yeah.
I know it might get lost per se in a Friday email, and then we'll do that and we'll put a time frame of by next Friday, not this upcoming Friday, but the following Friday. That gives you guys time to look at anything for the Thursday meeting. So we'll do that time frame, and an hour should be enough for us to sit back, for the chairman to have some more thought over some things, vice chairman, and we'll go from there, try to put it together, and then have a final document come out of that meeting. I mean, I know everybody knows Mr. Mayor. This was one of the things that he was passionate about, just as Robert's Rules of Order. So this is probably a fine-tuned legal document from the get-go without needing much changes to it. So I know he loved this document.
You clearly love the scope of the Ways and Means Committee, too. It's pretty evident in there, so I've got some thoughts on that.
All right, seeing none. Anything else that are miscellaneous? So an hour would be probably enough. I'm planning on 5 o'clock for the county board meeting for us to have our next conversation. Does that give you enough time for your pre-meetings? Okay. All right, seeing none. Meeting adjourned. Thank you.
Thanks.